Ladies and gentlemen, lend me your ears and your eyes. Diva Divine Light, live from Brooklyn, New York.
Know your lane for what you saying, yo. Said it with my 9 million with the dilly, yo. When I be on the mic, yes, I do my duty, yo. While up in the club, every while in the studio. You don't wanna violate, nigga, really and truly, yo. My main thug, nigga named Julio, he moody, yo. Like a nigga that'll slap me with the tulio. Bitch, nigga scared to death, act fruity, yo. Fuck that, look at shorty, she a little cutie, yo. The way you shake it, make me wanna get all in the booty, yo. With no lane for what you saying, yo.
Diva Divine Light.
Really my heart to me. Fuck me, see, that's what you got for me. Put more than years with my eyes to see. Still $1 in a place to be. If you really my heart to me. Fuck me, see, that's what you got for me. Put more than years with my eyes to see. Still $1 in a place to be. If you.
You're watching Diva, the Divine Light. A fun-loving, caring, passionate person who talks about sex, celebrity, and real-life issues, and even abuse. So hit that like button and make sure you share the show.
Really my heart to me. Fuck me, see, that's what you got for me. Put more than years with my eyes to see. Still $1 in a place to be. If you really my heart to me. Fuck me, see, that's what you got for me. Put more than years with my eyes to see. Still $1 in a place to be. If you really my heart to me. Fuck me, see, that's what you got for me. Put more than years with my eyes to see. Still $1 in a place to be. If you really my heart to me. Fuck me, see, that's what you got for me. Put more than years with my eyes to see. Still $1 in a place to be. If you.
Here comes the pitch, and it comes in wide. On the combo.
Yo, 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 yo. Good evening, good evening. Good morning and good afternoon to some. How's everybody doing out there in this YouTube world? How are we doing in the real world? I hope everybody's doing good, I'm doing good. Who's in here? Let's see who's in here. Cherie! What's up, lady? How are you, honey? Good evening, baby. Good evening to everybody in the bushes. What's up? Jump into the chat. Say hello. What the hell is going on? Y'all better jump in the chat. It's Friday. What? Say hello to the lovely diva and the people in the chat. Cherie. Well, everybody's done read these transcripts, from the brief. Hey, wifey. What's up, Rico? ¿Cómo está, chulo? What's up, baby? How you doing, sweetheart? Charisse, what's up, chula? What's up, mama? I miss you, ladies. And you too, Rico. What's going on? So I hope everybody's doing good on Friday. So, as I was saying, everybody has read this brief already. Ty! What's up, baby? Hi, my love. So everybody's read this this brief, the reply brief from R. Kelly. And yeah, so I'm gonna read it too. You know me, I'm very animated when I read, guys. So I hope you guys enjoy my reading. People have broke it down in their own ways. And some people, we know get it right. We know how it is out there. We got people who are doing it right, and then we got people who are just all over the place. Oh my God. I cannot. Mm. That's all I gotta say. I ain't, I ain't gotta say much. I'm just gonna read. That's it. That's all. That's all I gotta do. I be making them mad just because I read. So let me continue to read. These YouTube streets are just ridiculous at this point. It really is. So, but I'm still here. I'm still here, guys. I'm still pulling through. This sector is dying. It's pretty much dead, you know. But I'm going to keep giving you guys updates until I can't give you updates no more about R. Kelly. And in between time, in the meantime, we do different things too. Um, I'm really like a true crime buff. I don't know how many of you guys are into true crime and things of this nature, but I watch a lot of stories about children and them going through abuse and stuff like that. And some of these stories that I see out here are just so horrible and sad. Hey, daughter of the Most High, what's up, lady? Thank you, Sharice. I appreciate you guys too for stopping by and always showing me your support. And for those who always give me a cash app every now and again, showing me support that way, that keeps me afloat too. I still gotta pay my pacer. Hey, Dahel, what's up, Chula? Yes. Okay, so Sharice is a true crime junkie, so at least I know she'll be here when I'm talking about the true crimes that I be watching. Like, I just want to try to maybe do reaction videos, and I think that's where I'm gonna go next with my channel. So I'm gonna be doing true crime reaction videos. So hopefully you guys stick around for me with that. And we'll do in between things and stuff like that as well. Sharice, I be watching Law and Crime too, girl. Oh, you listening and cooking? All right, my love. Hey, shorty. What you cooking, the hell? I made some, well, I had leftover yellow rice and white rice. So I just kind of just heated up the rice. It's Friday, so I didn't have to really cook like that. What I did was I had two small pork loins and I cut them up into little pieces and I seasoned them up real nice and juicy and stuck it in the oven, baked them, took it out, and had some green beans and some yellow rice or white rice, whichever one you wanted, with some pork tenderloins, just like that, baked in the oven. That's what I cooked. Okay, so you got fish. All right, okay. I had green beans too. Okay, and mac and cheese. Sounds good, girl. Sounds good. Enjoy. I'm glad you enjoyed, sweetheart. Enjoy when you do. When you eat. Yes. So, like I was saying, everybody's done read this. This is gonna sound redundant if you guys already done been through the streets and watched everybody doing their thing and doing it in their own way, in their own style. So I'm here on repeat, doing it for the fourth, fifth, sixth, seventh time, however many times. But these streets have been real funny. And it's because, you know, I just, it's weird. I just find everything weird, ironic, karma, drama. Ugh, gives me headaches. So that's why I really don't speak much about these streets, because these streets give you headaches. I'll tell you that. That's for sure. That you'd be like, oh my God, did I just really listen to this? Did I really take 20 minutes out of my time to listen to this? Did I really take a half an hour? Did I really? Did I skip through the video because I just can't watch all of it? Like, oh my God, girls, ladies, and gentlemen, welcome to the world of YouTube. Okay, yeah, Sharice, I get it. I take my breaks. You see me, I don't be on all the time or every day, all day. That I mean, no, I say so. I don't do that. No. I have real life. Life is where I live. Reality is where I live. YouTube is YouTube. I just like to give updates right now. And like I said, maybe later on I'll turn it into something a little different. But right now we're going to stay focused and we're going to stay on R. Kelly's neck. That's just what the fuck it is. And people don't like it. And it's okay. It's okay. You will be okay to not like me talking about R. Kelly and his crimes that he has done, committed, and been convicted for. Not once, but twice. And he's lucky it wasn't 4 times. And he's lucky he only got 31 years. Mm-hmm. He's lucky. He's lucky. God is on his side. Yeah. God gave him a break. He did. He didn't give him 129 years. He didn't give him, life. The 30 years is more or less kind of like life, but he could get out by the time he's about 78 years old. 75, something like that. By then, he should be a different person. So he's not going anywhere. This appeal is not going to make it. It's not. Oh my God, the hell, that's funny. Yes, Ty, they stay delusional. It's just it's part of being a flying monkey. That's what it is. It's part of being that. You are there to enable and protect your God, your king, your gang of kids. Hmm. So, yeah, they gave him a break. I'm sorry, but they gave R. Kelly a slap on the ass, a little pat. They just said, look, hey, purple, what's up, my love? They gave him a little slap on the ass. That's all they did to him. And they're mad because they think he shouldn't even be in jail. Because to them, R. Kelly was not abusive to these girls. To them, R. Kelly didn't sleep with minors. They were all adult children. I mean, I don't know. It's just funny to me. He don't have herpes, but he has herpes. He's been taking Valtrex since like 2004. I mean, he spoke about the package in Trapped in the Closet. What the fuck you think he was talking about? He was talking about him giving herpes to everybody. That's what the fuck he was talking about. You see, you people don't understand R. Kelly. You have to really listen to his music to understand the man and where he comes from. So I don't know about y'all being fans, because if y'all didn't understand that, I mean, wow, because he was talking about his package and giving out the package. He wasn't talking about AIDS. He was talking about herpes, y'all. He was talking about herpes, okay? And how he slept with the cop and the wife and the midget and the other girlfriend. Right. He just literally told on himself. You're absolutely right. You took videos because this turns you on. Yeah, okay. So it turns you on to watch you have sex with 14, 15, 16-year-old little girls. I mean, I'd probably be more turned on if it was me, if I was watching myself have sex with a 25-year-old, 35-year-old, somebody my age. That would probably turn me on. I mean, that's normal. Yeah, no. If you want to be a pervert, I mean, watch yourself having sex with women that are your age. I mean, really. But you wanted to keep trophies, so you got, what? Look at where you at today because you wanted to have trophies on your wall. Remember the wall full of all the videotapes? Yeah, your trophy wall, because that's what it was for you, a trophy wall. Where you just picked one and just popped it in and watched it. It was like, oh, look, it's me with fulana. Oh my God, that's right. She said she was 14. Oh my God, I love it. And you're sitting with your junk in your hands and you're just whacking away and being excited and just nasty all over the place because they don't like it when we call R. Kelly nasty. And then you got bumps. Like, really? You got bumps. You got bumps. You get bumps every now and again when you get stressed out. And you get bumps every now and again when you wear leather pants and you start sweating and itching. Yeah, no. You get bumps every now and again when you get sick, you catch a cold. These things happen. And every now and again, you might say, oh, all right, I got a bump. I really need to have sex. It is what it is. So I'm just going to bend this girl over because I can. Hey, Missy, what's up, my love? Hey, Queen, what's up, baby? Like, so let me bend her over. I give her herpes. All right. Then I'm having sex with other girls. I'm taking Valtrex in between that just to prevent me from getting any outbreaks, And so therefore, when I'm taking my meds, I don't give anybody any herpes because I'm taking my meds, So I'm good with that. But then every now and again, I don't take my meds and I have an outbreak and I wind up giving it to somebody in their mouth, or I wind up to giving it to somebody in their cool poo nani, But it's okay because I don't let nobody know that I got herpes. I just go and just have sex randomly because I feel like it. Yeah, so that's R. Kelly for you. Yeah. He's been like that for what, 31 years? Yeah, 25, 30. Yeah, 30 years. They should have did this shit 30 years ago. Right. Girl, this is right. This is good luck for him. He just doesn't want to be behind the bars, Bendito. Hey, Kat, what's up, my love? How are you, sweetheart? God bless you. I hope you're doing good. It's good to see you in here. So, yeah, guys. So I've been rambling for 20 minutes, just, So we all know R. Kelly is guilty. We see the evidence. Bonjean has an issue. She's saying, oh, R. Kelly is not an enterprise because his associates, in fact, were not really associates because they didn't really commit crimes. They were just there. They were just employees. Rah, 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 rah. But I could have sworn I went through this already. I'm not gonna repeat it again as far as what I talked about with the RICO and the enterprise and the meaning of the association in fact and It doesn't matter because he's still an enterprise, because of the fact that he was part of it, he owns it, he sat back and let people commit crimes, he sat back and paid people to watch him do crimes, so Bonjean's argument is moot and dead in the water for me. Moot. Complete. Moot. I don't give a shit. Her argument is going to go right in the garbage. I'm telling you. The judges are going to look at her like she's crazy. And they're going to say, well, listen, Miss Bonjean, but they did prove it because they're letting you know that he used his enterprise not only to represent his brand, his music portion of it, but in between that, he used the people around him to gather up girls for him, recruit them, give out their phone numbers, to give out his phone number. And then the girls would call him. Some didn't, some did. He would have meet and greets. He would let the girls go backstage, sign autographs. He would go to McDonald's. He would talk to the people at the window, like Lewis, and say, I want a cookie. I want a cookie. And then the kid in the window would literally be his cookie. And if he was a boy, he would do a crawl up on the boy, snap his fingers, get on his knees and crawl, baby, crawl like a kitty cat, an alley cat, meow. And then he will whoop it out and go, oh my goodness, you're so big for somebody who's 16, 17 years old. Let me put it in my mouth. I said, my motherfucking mouth, so I could just suck you out. Yeah. And then he would snap his fingers, right? And then the girl would come out. Because these girls have Stockholm syndrome at the end of the day. And what would happen? He would say, let's get together, guys. I want to videotape this shit. I got to get it on camera. Wait. Before you do that, I want you to pee on yourself. I want you to play with your pee. Yes. This is what I want you to do. You know what? This is punishment for you because you did not look good on the other video. You cried too much, bitch. You cried too much. So therefore, this is your punishment. I need you to poop in a cup and then smear it all over you. But no, you heard what the fuck I said, bitch. Right? But this is okay, according to people out here in these streets. This is okay. This is not abuse. This is love. These were girls in relationships because R. Kelly was a Romeo pimp. Let's not forget that. R. Kelly is a Romeo pimp. Okay? He didn't sell the girls. He was tricking for himself. R. Kelly's a trick. I love you, my sweetheart cat. God bless you, my love. Thanks for stopping by, baby. We pray for you, sweetheart. May you have healing quickly. It's going to take time, but don't worry, mommy. You'll get back to it. Maybe you should talk to Classy. That's hard to lose a child. May she rest in peace. And may you and your family receive many condolences and Much healing. Puzzle pieces. Happy belated birthday. Everybody say happy birthday to Puzzle Pieces. Our Leos are still in the building. Virgos are approaching. Mm-hmm. Right, Cherie? He was passing it out like candy, you know. Some girls did have the candy and some girls didn't get the candy. That's what it was. You know. You're welcome, sweetheart. Did I say what's up, Queen? What's up, Queen? So R. Kelly's crying, you know, because he's got 30 years. You don't know, brother, gonna do 30 years in here. Because I didn't do anything but be a player. That's what I did. I was being a player. The fuck out of here. Shut the fuck up. Goddamn player. He was being a player. He was being a pimp ass hoe. That's what you was being. That's what you was doing. You was being a pimp hoe. Mm-hmm. We know. So now let's get to this bullshit. Now, y'all know I'm not facing the screen, but I do have my phone. Okay. All right. Let me take another sip of water. So, this is document 134 from case 22-1982. This was put out on August 16th, 2023. That's when it was filed. It's 27 pages long. And this is from Jennifer Bonjean. This is her brief, her reply to the government. So this is from the United States Court of Appeals for the Second Circuit, United States of America, which are the appellees, versus Robert Sylvester, the molester, Kelly, aka R. Kelly, which is the defendant, as we know to be the appellant. On appeal from the United States District Court for the Eastern District of New York, reply brief for defendant-appellant Robert Sylvester Kelly. This is by Jennifer Bonjean, Bonjean Law Group. And then we got the table of contents. I'm not going through that. Then they have, the case laws that they cited in this brief. And then we're going to go kick into the argument. Thank you, Purple. Oh, thank you, Purple. Oh, thank you, Puzzle Pieces. Sorry, I thought it was Purple. Thank you, Mama. Thank you. So now, Bonjean's argument is, let me put my phone over here. Wait, let me fix this up so I can look. Now, her argument here with her reply to the government, who argued, right, from her original brief that she put in, the government failed to prove the defendant guilty of racketeering, where the record is devoid of evidence of an enterprise comprised of members who shared a common illegal or fraudulent purpose, and where the defendant and the alleged enterprise were indistinct. So, in other words, she's saying that you can't differentiate, okay, the enterprise, who share a common ground for a illegal or fraudulent purpose. So in other words, she's trying to say that you saying R. Kelly had an enterprise, but yet there was really no enterprise because of the fact that the people that worked for you were doing just that. They were just working for you. They weren't committing crimes because they didn't know they were doing these crimes. Right? So transporting the girls back and forth, that was just doing their job. They didn't know they were committing crimes. So this is her plea, is what she's trying to say. This is what I'm understanding. If this is what I get out of reading all of this. So she's trying to say that how can you say that they're an illegal criminal enterprise committing crimes which you fail to prove because the people that worked for him were just doing just that, being employees. His inner circle didn't share the common purpose as to making child pornography. So, in other words, she's trying to say, well, R. Kelly did these things, right? Let's just say, right? Hey, Diva Time, what's up, sweetheart? She's saying, being that R. Kelly, let's just say, right, did these things, right? But yet you're saying he's an enterprise. But how is he an enterprise when the enterprise, the people that you say are his enterprise, his inner circle, right? Well, they didn't sit there and set up the cameras with him and sit there and direct people and tell them the lighting here needs to be bright and you need to sit in that chair and you need to give him WAP while he's giving her WAP, and we're going to do it right here standing on this wall. And the other ones with the camera, like say cheese, okay, and the other one's fixing the light. And so she's saying that because R. Kelly's inner circle wasn't sitting there directing and making child pornography with R. Kelly, how can you say that the enterprise had a common purpose to make child pornography, right? How can you say that the enterprise had a common purpose to recruit girls? Because it's not like she's saying R. Kelly went and said to them, all right, listen, I'm giving you guys these numbers. And the reason why I'm giving you guys these numbers is because I want you to make sure that you guys pick out the right girls or the girls I point out to, okay? And you give them wristbands so they can see me backstage. You give them my number so they can call me because I want to make sure that we go to the hotel because I'm going to take them to the hotel so we can have sex, okay? Now, remember, if you see a girl that's like 15 and she comes through anyway, just act like you don't even know she's 15. Act like she's 19 and let her through. So this is Bon Jean's argument, guys. This is basically what she's saying here. That R. Kelly didn't have a common purpose with his enterprise. You can't say that, like say for instance with the mafia, right? They have a common purpose to what? Let's say rob a bank, right? So their common purpose is to go out and rob the bank together. So one's going to be the lookout, the other one's going to be the driver. You know, they're going to do illegal acts with a common purpose, and that's to rob the bank and get money. So this is Bon Jean's argument. This is what basically all of this is what she's trying to say as far as the racketeering and enterprise portion goes. That's what I got out of it. And then she had a smart little remark in here trying to say that it's funny because how can he be an enterprise when the enterprise didn't help him? What was it she said? Oh, here we go. Let's read it. Okay, let me read it. Let's get into it. Hey, LaShawn, what's up, baby? So now the government largely concedes that it did not prove beyond a reasonable doubt that defendants' inner circle shared a common purpose to engage in a fraudulent or illegal course of conduct. Okay? So, as we know, the illegal conduct is the Mann Act, the sexual exploitation, right? The herpes, this, that, and the third, right? So, instead, the government makes a frivolous waiver argument and insists that it was never required to prove a common purpose of illicit conduct in the first place. Even though the indictment charged it, the government now seeks to constructively amend the indictment to remove an essential element of its enterprise theory to circumvent its proof problems. See what I'm saying? So then she says, the government makes virtually no effort to address defendants' separate contention that evidence of an enterprise was insufficient where defendant and the alleged enterprise were indistinct. Okay? So the government's evidence at its best shows only that defendant used his status and authority to engage his employees in routine, sometimes odd tasks that unwittingly facilitated his private sexual activities. That the government suspects that some of defendants' employees turned a blind eye or knew more than they let on is not sufficient evidence that the members of the so-called enterprise shared a common purpose of promoting. Thank you, Purple Purple. That the members of the so-called enterprise shared a common purpose of promoting defendants' illegal sexual conduct. A necessary element to the charged RICO offense. So, like I said, because the employees weren't in the room helping him make films and they weren't witnesses to the actual sex going on and they didn't actually know that R. Kelly was going to be having sex with these girls, they weren't an enterprise with a common purpose. Are you for real? Is this really what's going on? I can't. SK, I love you. Hi, baby. Kiss the baby for me. So let me know, guys, what you think about that. Yeah. So Bo Jean, she's throwing sticks and stones at the wall and sending prayers out. Like, I pray. Pray, I pray. Prayer change, right? Yeah. She pray. Hey, Aisha, what's up, my love? So now Bonjean's complaining about the argument that the government had about the jury instructions. Okay? Because she's replying to what they had to say. Give me 1 second. I'll be right back. All right, so now Bonjean is going to reply about the jury instructions and how the jury instructions were not deficient. They weren't, the evidence was. So she says, preliminarily, the government did not argue below that defendant's Rule 29 challenge to the government's evidence of an enterprise was misplaced and that his objection was actually to the court's jury instructions. More importantly, the district court concluded that the question of whether an enterprise was proven beyond a reasonable doubt was a proper Rule 29 claim. So the government's attempt to recast the sufficiency of the evidence challenge as a defective jury instruction issue is specious. Having proposed the jury instructions, the government knows that they accurately stated the law, that they included that they told the jury that the government was required to prove an enterprise as charged in the indictment. The problem is not with the instructions, it is with the proof. So she's there saying that, the government's assuming that it had to do with the instructions. No, it has to do with the proof. Thank you, Diva Time. Miss you too, Mama. So, critically, the government fails to acknowledge that the jury instructions incorporated language from the third superseding indictment, including the government's claim that the common purpose of the enterprise was to engage in an illegal common purpose. So she's saying that the common purpose, again, like I said, was illegal, that they all had a common purpose to do something illegal together as a group. Some type of conspiracy is what she's trying to say. Usually RICOs have to do with conspiracies, activities that groups do together for a common purpose. This is what she's saying here. So, in the instruction setting forth the existence of an enterprise, the jury was expressly instructed that the indictment alleged that the purpose of the enterprise were to promote R. Kelly's music and the R. Kelly brand, to recruit women and girls to engage in illegal sexual activity with Kelly, and to produce pornography, including child pornography. The instruction also told the jury that although the government is not required to prove each and every allegation about the enterprise. So she's saying that the instruction also told the jury that although the government is not required to prove each and every allegation about the enterprise proved must be essentially the one alleged in the indictment. In other words, the government conceded that it was required to prove that defendants' employees, or so-called inner circle, shared a common purpose to engage in illegal or illicit conduct, namely to recruit women and girls to engage in illegal sexual activity with Kelly and to produce pornography, including child pornography. So again, that it was required to prove that the government's employees, or so-called inner circle, this is what she's saying. Hey, honey bunny, what's up, my love? Good to see you, mama. Good to see you. So now, for me, I don't know about you guys. I mean, I know all of us, a lot of us over here, we heard the transcripts and everything, you know. The government proved that he had an enterprise by the people that controlled, that were on top, right? The commission. Diana Copeland, Demetrius Smith was the first, right? Diana Copeland, Barry Hankerson. They actually had an engineer over there. They had a couple of other people. Can't remember. Daryl McDavid, June Brown, a couple of other people, right? That's the commission, right? R. Kelly's the top of the head, then comes the commission, and then comes everybody else. His inner circle, his entourage, because you got the business manager, the lawyer, and everybody else on top. You got his personal assistants who are runners. Then you got drivers who just drive. You know, those are the drivers that work for R. Kelly, and then you got Ubers that they rent. So every now and again, one of his employees will drive one of his guests to the hotel or to the concert or to his home. And these were things that were testified. Now, the point that the government is trying to make is how he had his inner circle moving girls around for him, whether they knew or not of what he was doing with these girls. He's the one that's on trial, not them. They knew they had to do what they had to do to get paid. And if some of them got paid to turn a blind eye, then that's what it was. The government proved that. That's for sure. People were booking flights, giving girls money, getting them food, making sure they were in their hotel rooms, making sure that when they got punished, they didn't leave their rooms. Come on. If they were locked in the Sprinter, there was somebody in there with them. Or outside, standing outside the tour bus while the girls were inside. Yeah, these things were proved. They were proven. So the government pretends that it never charged an illegal common purpose, pompously declaring the party's proposed instructions adopted by the district court set a benchmark for the government to meet. The government met the mark, and Kelly now objects that the government did not instruct sufficient evidence for the jury to find that another, previously unspecified, required was met. And then it says, she points out the government's brief, number 41, page 41. Defendant agrees that the jury instructions set a benchmark for the government to meet. One of those benchmarks was to prove beyond a reasonable doubt that the common purpose of the enterprise was to promote defendant's illegal sexual activity. Look at what she said here. One of those benchmarks was to prove beyond a reasonable doubt that the common purpose of the enterprise was to promote defendant's illegal sexual activity. This is what she's saying. How is it that the enterprise is supposed to... When did the government say that they were going to promote? They just said to promote his brand and his music. And it was to recruit girls for illegal sexual activity. The government never said anything about promoting the defendant's illegal sexual activity. When did y'all ever hear that? Did y'all ever hear that? Did y'all ever hear that at any time in any place? Because I don't remember that. What's she talking about? Please help me. What's she talking about? What is she talking about? That's crazy. She's just throwing sticks and, like I said, everything in the kitchen goddamn sink. You go, girl. Whatever you can, because that's not gonna work. That's not gonna work. Then she states the government failed to meet that benchmark. Defendant did not introduce a new unspecified requirement. Rather, the illicit common purpose element was charged, set forth in the jury instructions, and the jury was instructed that the government was required to prove the enterprise as charged. The government simply failed to prove the charged enterprise theory by arguing that it was never required to prove a common purpose of illegality as the indictment charged. Right, because you can charge someone under a RICO whether they are a legal enterprise or a illegal enterprise. R. Kelly was, shall I say, a legal enterprise who did illegal crimes. That's what I understand. I don't know, prove me wrong, whatever. The government is attempting to constructively amend the indictment on appeal to remove that essential element of the RICO enterprise theory. A constructive amendment occurs when the evidence presented at trial alters the essential elements of the charges specified in the indictment. Then she cites a case law that happened in 2018 in the Second Circuit at the appeals court. And the indictment here in the United States versus Dove, okay, in this case, in this indictment here for the United States versus Dove, it alleges that a common purpose of the enterprise was to promote defendants' illegal sexual conduct. That the government now claims that it was never required to prove the illegal common purpose is nothing more than an unconstitutional constructive amendment to the indictment. So she's trying to say they're trying to change the words of the indictment. They're trying to change it around. So the government alternatively argues that even if Kelly's brief challenging the sufficiency of the evidence were interpreted to challenge the jury instructions, the error is not plain error. The error is no error in the jury instructions, plain or otherwise. The jury was expressly told that the government was duty bound to prove its charged theory of an enterprise, which included a theory that the common purpose of the enterprise was to promote illegal sexual conduct, not merely promote defendants' music. The government failed to prove its theory of an enterprise, and the conviction must now be reversed. Girl, you are crazy. The government can cite to no authority that allows it to amend the indictment on appeal to fundamentally alter its theory of the purpose of the enterprise. Womp, womp, womp. That's what I think of that. An enterprise requires a shared purpose of fraudulent or illegality as the government charged in its indictment. The government contends that it was not required to prove a shared illegal or fraudulent course of conduct. This position by the government represents a profound change of heart, where it charged defendant with an enterprise that had a common purpose of an illegal course of conduct, and then instructed the jury that it was required to prove that illegal common purpose. As argued above, the government was required to prove its theory of a common purpose as pled in the indictment and as set forth in the jury instructions. Recognizing that its proof of a common purpose as pled in the indictment was insufficient, the government repeatedly attempts to recast defendant's argument as a challenge to the structure of the organization. Defendant's RICO challenge has nothing to do with the structure of defendant's organization. It is well established that an enterprise can have either a legal or illegal structure. But an enterprise cannot exist without its members sharing a common purpose to engage in a particular course of fraudulent or illegal conduct, as the government knows, having pled such a purpose in the indictment. To hold otherwise would mean that any rogue bad actor operating in a legal organization can be prosecuted under RICO. She's funny. Yeah, Little Shop of Horrors. That was a good movie. I saw the movie. The play I'm pretty sure is off the hook. Um The government attempts to distinguish defendant's authority, but repeatedly succeeds at proving defendant's point. For example, the government argues that in First Capital Assistant Management versus Satinwood, that's another case that was in the that went into the Second Circuit in 2004. And in this case, it says that the alleged common purpose was one grounded in fraud to conceal assets from creditors and the bankruptcy court. And thus, this court necessarily analyzed whether such a common purpose had been adequately alleged. And then she cites the government's brief at page 44. And the government seems to forget that it too alleged that the common purpose of the enterprise in this case was to promote the defendant and his illegal sexual conduct. Consistent with the government's own argument, this court should necessarily analyze whether such a common purpose has been adequately proved. So she's letting the judges know that that this court should necessarily analyze whether such a common purpose has been adequately proven. Then she says the government's attempt to distinguish First National Bank versus Gelt Funding Corp., another case that happened in the Southern District of New York in 1993. And also they cite the Mall versus U.S. Life Title Insurance Company of New York, and that was in the Southern District of New York in 1987. And it says that those cases that were cited, she says that they similarly fail. Those cases that they cited are failures to this case. In other words, they don't belong here. That's what she's trying to say. So in both cases, the complaints alleged, this is what went on in both these cases. In both cases, the complaints allege the common purpose of illegality, just as the government did in this case. Having charged the common purpose of illegality amongst the so-called member of the association, in fact, enterprise, the government was required to prove that common purpose of illegality. Indeed, if the government had not charged a common purpose of illegal conduct in this case, the defendant's motion to dismiss the indictment would have prevailed. So she's saying that if they would have talked about the conduct in this case, if the government had not charged a common purpose of illegal conduct in this case, then that means when R. Kelly put in his motion to dismiss the indictment, he would have won that. It would have been dismissed. He would have prevailed, right? So now she's saying that the government suggests that Satinwood, First Nationwide, and Mall are not good law because the cases preceded the Supreme Court's decision in Boyle versus the United States. That was in 2009, in which that was in the Supreme Court, in which the Supreme Court held that an association in fact enterprise need only have a purpose, which is relationships amongst those associated with the enterprise, and longevity sufficient to permit those associate to pursue the enterprise's purpose. Now, Boyle does not help the government's case. That's why the government used Boyle, because they just want to prove the association in fact. They didn't want to prove that these other people committed crimes with R. Kelly because some of them didn't even know that they were committing crimes. They were just doing their jobs. And some of them decided to know what they know, what they think they knew, because everybody was whispering and rumors were always flying around. But they turned their blind eye because they needed to get paid. So that's why the government used the associated in fact clause here. You would say the case of Boyle. Now, in Boyle, the defendant was charged with a number of bank thefts that were allegedly conducted by a group of loosely organized individuals operating within a larger structure. As the court observed, the participants in these crimes included a core group, along with others who were recruited from time to time. Each theft was typically carried out by a group of participants who met beforehand to plan the crime, gather tools, and assign the roles that each participant would play, such as lookout and driver. So the participants generally split the proceeds from the thefts. The group was loosely and informally organized. It does not appear to have had a leader or a hierarchy. The Supreme Court held that this association, in fact, qualified as an enterprise for RICO purposes, notwithstanding the absence of a clear leader. So the court was not presented with the question, nor did it answer whether the members of an association, in fact, must share a common purpose to carry out an illegal course of conduct, or whether a single bad actor acting within an organization can be guilty of RICO. So indeed, in Boyle, the association, in fact's entire purpose was to carry out bank robberies, a decidedly criminal purpose. So if anything, Boyle drives home defendant's point that the evidence in this case did not show that the members of defendant's musical collective, whether characterized as formal or informal structure, engaged in conduct demonstrating a shared purpose to carry out an illegal course of conduct. The government purposefully distorts defendant's challenge as one of the structure of the enterprise, rather than the purpose of it. If within the context of a legitimate business, as defendant's business was, there does not exist a group of individuals with a shared purpose to engage in a course of fraudulent or illegal conduct, there simply is no RICO enterprise, even if the head of the legitimate business is independently engaging in illegal behavior. One man is an enterprise, Bonjean. An individual, sweetheart, an individual, a sole proprietor to his enterprise. Yes, I know, you're just doing your job. The government points this court to the language in the United States versus Turquette, a case in 1981, and De Adiario versus De Adiario, which was in the Second Circuit of Appeals Court in 2018. Now, for the proposition that an association in fact enterprise need not have some sort of illicit, much less fraudulent common purpose, which the government cited here, they said in page 48 of the brief, the government did not take this view when it presented its theory of a common purpose to the grand jury, or even when it afforded its jury instructions. In any event, neither the Turquette nor the Adario courts were presented with this precise question, because there was no dispute about whether the common purpose of the alleged enterprise members were engaged in a criminal or fraudulent course of conduct. As explained in his opening brief, apparently overlooked by the government based on Footnote 7 of its brief. In Turkey, the court was tasked with deciding whether an enterprise could include an entirely illegitimate enterprise. In its discussion, the court compared various associations, in fact, that were entirely criminal in nature or were a combination of illegal and legitimate activities. Turkey did not provide any example of an association, in fact, where its members shared only a legal purpose. Similarly, in Diario, the association, in fact, enterprise had a legitimate structure, insofar as its stated purpose was to settle the estate. But as this court observed, the defendant and other members of the enterprise shared a common and unambiguous purpose of carrying out a fraudulent scheme to steal from the estate. Now, these cases stand in stark contrast to the instant one. Here, the evidence, at best, shows that defendant used unwitting low-level employees to carry out an mundane task that facilitated his own criminality. Indeed, the government has failed to cite a single case that suggests, let alone holds, that an enterprise is established when a single bad actor uses status and authority within an organization to enable his private misdeeds. So she's saying that these people were idiots, low-level employees who carried out whatever task was told. The government also cites United States versus Cianci, and this was in the First Circuit in 2004, and United States versus Feldman in the Ninth Circuit in 1988. These were two cases that the government cited for the proposition that to establish a RICO enterprise, the government need to not show that a corporation has acted with purposeful or unlawful intent. This argument misses the mark. Defendant has never suggested that the government's enterprise evidence was insufficient because his legitimate business entities did not act with an unlawful intent. Defendant's argument is simply that the government did not prove that the charged association, in fact, enterprise shared in any illicit common purpose. Neither Cianci nor Feldman hold that association, in fact, enterprise can exist without its members sharing an illicit common purpose. Indeed, Cianci says the opposite. There, the court held municipal entities can be party of an unlawful purpose, association, in fact, enterprise, so long as those who control the entities shared the purpose of the enterprise. RICO does not require intention or purposeful behavior by corporations, charges as members of an association, in fact. A RICO enterprise animated by an illicit common purpose can be comprised of an association, in fact, municipal entities, and human members when the latter exploits the former to carry out that purpose. The Cianci court expressly acknowledged that the members of the association, in fact, enterprise, must be motivated by an illicit common purpose, even if the municipality itself need not act purposefully. As the court noted, an association, in fact, enterprise consisting of people and entities can exist when the people use the organization to carry out their shared illicit common purpose. The court did not hold that an association of fact enterprise can consist of people whose only purpose is to carry out a legitimate and legal purpose. So R. Kelly's team did legal and illegal activity, whether they knew or didn't know. Period. That's what it is. C. The government did not show a common purpose of any illegal or illicit conduct as charged. The government concedes, as it must, that its indictment charged that the common purpose of the RICO enterprise was to recruit women and girls to engage in illegal sexual activity with Kelly and to produce pornography, including child pornography. The government generally claims that it proved the illicit common purpose, but almost immediately reverts back to its faulty legal argument, namely that defendant's mere use of his employees for tasks such as driving female guests from one location to another or providing a woman of unknown age defendant's phone number is sufficient to show a common purpose of recruiting women for illegal sexual activity and the production of child pornography. The government expressly argues the evidence proved that Kelly used his fame and popularity in the music business, combined with a network of individuals at his disposal, to target, groom, and exploit numerous victims for his own sexual gratification. Even accepting this statement as true, it does not constitute sufficient evidence that the network of individuals shared a common purpose to promote defendants' illegal sexual conduct. Again, the government was not trying to say that his people, his network of individuals, his enterprise was to promote defendants' illegal sexual conduct. It was to recruit, not promote. You see how she's trying to wordplay? Now, the government relies, now I know these judges ain't dumb, so good luck with that, Bonji. The government relies on the United States versus Minicone. And this is a case from the Second Circuit in 1992. That's the appeal court. And it says, for the proposition that the government was only required to prove that the enterprise's common purpose was to promote defendants' music and brand, not defendants' illegal sexual conduct. The government grossly mischaracterizes the holding of Minicone, falsely suggesting that Minicone supports its contention that an enterprise need not have an illegal common purpose if a defendant merely uses his underlinings to carry out his private misdeeds. In Minicone, the defendants were charged for their alleged involvement in a wide-ranging criminal enterprise that profited from extortion, loan sharking, illegal gambling, and trafficking in stolen property. The defendants challenged their convictions on the grounds that the racketeering activities were not sufficiently related to the RICO enterprise, not that evidence of an enterprise was insufficient. So, contrary to the government's argument, the court did not suggest an enterprise exists when a defendant is enabled to commit the predicate offenses solely by virtue of his position in the enterprise. Rather, the court's statement pertain to the vertical nexus, which is the link, requirement between the RICO enterprise and predicate racketeering acts. It was not a declaration that a RICO enterprise can exist, even where the members have no common purpose of carrying out an illegal course of conduct. The government spills unnecessary ink on its argument that the predicate offenses are related to the activities of the enterprise, detailing its evidence of the predicate acts. If the government had proved the enterprise as charged, the government's relatedness claim would be well taken. But as discussed at length, the government failed to prove an enterprise. There are no predicate offenses, just standalone charges that are time barred. The government insists that despite the fact that it charged an illicit common purpose, it was not required to prove one. Alternatively, the government claims even if it was required to prove an illicit common purpose, it satisfied its burden because defendant's employees knew he mistreated his girlfriends. The government revives its closing argument, drawing sweeping and unsupported conclusion about the evidence that borders on misrepresenting the record. Cites to the record are notably lacking, and the government seems to rely heavily on the PSR, which is repellent with hearsay evidence that was never presented to the jury. What? She's saying that the government is relying heavily on his PSR report. What? When? What? What? Okay. I don't know where she get that from, but okay. But even if the government's greatly embellished version of the evidence was true, its evidence showed only that a handful of employees whose employment with the defendant was short-lived turned a blind eye to defendant's occasional mistreatment of his adult girlfriends. What? Diana Copeland was there for many, 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 many years. Cheryl Mack was there for many, 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 many years. All those other guys, I don't know, they were there for years, and some of them were there for months, maybe 2 years, tops. Sorry, guys, my throat's getting dry. Hold on. I'm gonna sip of water. You see how she threw in that word, adult girlfriends? Whether they were adults or minors, he still mistreated them. The government writes in its statement of facts and later incorporates into its argument that Kelly and his inner circle assisted Kelly in his professional and personal life. Right, that's why he had personal assistants and managers and tour managers and runners and all these people, right? Also recruiting and maintaining Kelly's female victims, right? Citing all of these places, appendix number, I forgot what the SA is for, and then government's page 5. She says, indeed, it is not even clear what the government means by recruiting and maintaining Kelly's female victims. But the testimony to which the government cites to back up this aggrandized narrative is devoid of facts from which the jury could have fairly concluded that defendant's employees shared a common purpose of promoting his illegal sexual activity. For example, Navarro did not testify to a single fact from which a rational juror could conclude that he recruited or maintained defendant's victims. Indeed, the prosecutor did not even question Navarro about defendant's victims, who she never identified in any event. Navarro testified to his general responsibilities as a road manager that included ordering food for defendants' female guests at the studio and driving them home when asked. In a misleading fashion, prosecutors repeatedly referred to defendant's female guests when questioning his former employees, knowing that those former employees would never agree that they knowingly facilitated defendant's sexual misconduct. But here, the government asked this court to just assume that female guest means defendant's victims. This court may not do so. She is funny. You hear what she's saying? Y'all. Let me see who else is out there. What y'all saying out there? I don't think she studied the case at all either. She went in talking crazy like, ma'am, do you know who the fuck you're talking? She thought it was single and about racism and money. I mean, part of the money thing is true, but he still did it all, and the charges are correct. It's crazy how he got off, and just like the anarchy is, he continued his abuse because he thought he was untouchable. Very well put. Very well put. He thought he was untouchable. She said, bit, not buyer. Okay, laugh out loud. So, but you didn't mention Cheryl Mack. That's who you need to be talking about. Cheryl Mack, Diana Copeland. A common purpose to ensure defendants sexually abuse women and children or produce pornography. I mean, don't she know about the incident with Azriel? I mean, she came into the room. R. Kelly had Azriel give him fellatio right there in front of her. Didn't he nut on her face and then make her walk out and everybody laughed at her? And you didn't mention that. Why are you using Arnold and Navarro? What? The government also cites to Arnold's testimony as support for its common purpose. Evidence claiming that Kelly's inner circle also assisted Kelly's female guests in arranging air travel and hotel rooms. Where's Diana and Cheryl? Okay, all right, hold on. A review of the citations provided by Government A 649 shows only that one of Arnold's responsibilities was to make sure Kelly and his team got to their destinations. Arnold's testimony, as cited by the government, is devoid of a single reference to Kelly's victims or girlfriends. The government takes enormous liberties with this record that borders on misrepresentations. The government claims that evidence of a common purpose was established because Kelly's inner circle required them to abide by several rules, including signing non disclosure agreements and getting permission for guests to use the bathroom. The government fails to explain how rules related to non disclosure agreements and obtaining permission to use the bathrooms in a studio or house shows a common purpose to promote defendants' alleged sex crimes. The government cites the testimony from Diana Copeland and Mayweather. Right. Okay, there we go. Where's Cheryl Max? You got to be in there too. Which established nothing more than they were defendants' personal assistants who arranged travel for some defendants' female guests, and that they interacted with defendants' girlfriends, none of whom were underage. Azriel wasn't 17. I don't know about Copeland with Geronda. I don't. Copeland never testified that she made travel arrangements for underage girls or that she was promoting defendants' illegal sexual activities. No, she said she wasn't from yeah, Copeland never testified that she made travel arrangements, right, for underage girls because she said she didn't know the age of the girls. That's why. But she did make those. She did make those travel arrangements, but you know, she lies. You know, she just lied to cover up for R. Kelly. You know, she just failed to mention that she knew Azriel was 17 years old. You know. So Mayweather, she said arrangements for underage girls or that she was promoting defendants' illegal sexual activities or production of child pornography. So Mayweather noted that defendant did not want her interacting with his girlfriends. It is unclear how this testimony showed a common purpose to promote defendants' illegal sexual conduct with women and children. Furthermore, that defendant's personal assistants retrieved prescription medications for him, including Valtrex, does not mean that those assistants had any reason to know that defendant was exposing his girlfriend to herpes without their knowledge in states where it is illegal to do so. It certainly does not establish a common purpose to promote defendants' illegal sexual activities. The remainder of the government's cited evidence merely shows that defendant imposed rules on his employees that were sometimes harsh and that he sometimes mistreated them. For example, the government makes much of the fact that defendant fined his employees for not abiding by his rules and allegedly requiring them to write letters to admit when they had done something wrong. That defendant was difficult to work for is not evidence that his employees shared a common purpose to promote his illegal sexual conduct. In sum, the government charged defendant under RICO alleging that the purpose of the enterprise was to promote defendants' illegal sexual conduct. The jury instructions set forth that theory and instructed the theory that the government was required to prove that theory. The government's evidence was insufficient. Defendant and the enterprise are not distinct. The government seems to suggest that the distinctness requirement is only applicable in RICO cases involving corporate entities, and that because defendant had an inner circle, the distinctness requirement was satisfied. Not so. The RICO state mandates that a person who engaged in a pattern of racketeering activity must be employed by or associated with the enterprise. Satinwood, Riverwoods, Chappaqua Corp versus Marine, Midland Bank, Bennett versus U.S. Trust, Brannon versus Boatman's First National Bank of Oklahoma. And these are other cases that were cited. And in these cases, it's about an entity cannot simultaneously be the enterprise and the person who conducts its affairs, permitting that would be tantamount to permitting an entity to associate with itself. One man is an enterprise, Bonjean. One man can own a business, work in the business, handle financial matters. A business owner can run many hats. And then he can tell people what to do, when to do it, and how to do it. Because he's the boss. Right. Because I remember having the owner of the establishment that I worked in working with me side by side. He owned the business. He worked there. He practically fucking lived there. Like, seriously. At this place I used to work back then when I was, young. Then she cites other case laws, and she says that in these other case laws, in its argument, the government doubles down on its claim that a RICO enterprise exists even when the defendant simply uses the machinery of his organization to enable his sexual misdeeds. If this is true, the enterprise has no function unrelated to the defendant. They are truly one and the same. In sum, the government's theory of a RICO enterprise was flawed from the start. The government's evidence, taken in its best light, showed only that defendant employed a collective of people over his 25-plus year career who promoted his career and his music. They did not share an objective to commit sex crimes against women and girls. Accordingly, the government failed to prove an enterprise, and defendant's racketeering conviction must be vacated. Womp, 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 womp. That's not going to happen. The government's evidence of intent as to the Mann Act violations related to Jane and Faith were insufficient. Defendant relies largely on the arguments contained in his opening brief concerning the sufficiency of the evidence as to the Mann Act violations related to Jane and Faith. However, it bears repeating that the government cannot and did not prove that defendant's motivating purpose in transporting Jane and Faith to California and New York was to expose them to herpes in violation of state public health laws. Give me 1 second, guys. I gotta wake up the husband. We're gonna go to a quick commercial break.
You are watching Diva Divine Light.
You can fuck with me if these red bottoms, these bloody shoes. Hit the scoop, I can get them both. I don't want to choose, and I'm quick. Cut a nigga off, so don't get comfortable. Look, I don't dance now, I make money move. Now gotta dance, I make money move. If I see you now, that means I don't fuck with you. I'm a boss, you a worker, bitch. I make bloody move. Now she say, gon' do what or who? Let's find out and see. Cardi B, you know where I'm at, you know where I be. Just a party, I'm there, I can play. I be in and out the bank so much, I know they tired of me. Honest, honest.
You are watching Diva Divine Light.
You can fuck with me if these is red bottoms, these is bloody shoes. Hit the scoop, I can get them both. I don't want to choose, and I'm quick. Cut a little nigga off, so don't get comfortable. Look, I don't dance now, I make money move. Now gotta dance, I make money move. If I see you now, that means I don't fuck with you. I'm a boss, you a worker, bitch. I make bloody move. Now she say, gon' do what or who? Let's find out and see. Cardi B, you know where I'm at, you know where I be. Just a party, I'm there, I can play. I be in and out the bank so much, I know they tired of me. Honest, honest.
You are watching Diva Divine Light.
You can fuck with me if these is red bottoms, these is bloody shoes. Hit the scoop, I can get them both. I don't want to choose, and I'm quick. Cut a little nigga off, so don't get comfortable. Look, I don't dance now, I make money move. Now gotta dance, I make money move. If I see you now, that means I don't fuck with you. I'm a boss, you a worker, bitch. I make bloody move. Now she say, gon' do what or who? Let's find out and see. Cardi B, you know where I'm at, you know where I be. Just a party, I'm there, I can play. I be in and out the bank so much, I know they tired of me. Honest, honest.
You are watching Diva Divine Light.
You can fuck with me if these is red bottoms, these is bloody shoes. Hit the scoop, I can get them both. I don't want to choose, and I'm quick. Cut a little nigga off, so don't get comfortable. Look, I don't dance now, I make money move. Now gotta dance, I make money move. If I see you now, that means I don't fuck with you. I'm a boss, you a worker, bitch. I make bloody move. Now she say, gon' do what or who? Let's find out and see. Cardi B, you know where I'm at, you know where I be. Just a party, I'm there, I can play. I be in and out the bank so much, I know they tired of me. Honest, honest.
You are watching Diva Divine Light.
You can fuck with me if these is red bottoms, these is bloody shoes. Hit the scoop, I can get them both. I don't want to choose, and I'm quick. Cut a little nigga off, so don't get comfortable. Look, I don't dance now, I make money move. Now gotta dance, I make money move. If I see you now, that means I don't fuck with you. I'm a boss, you a worker, bitch. I make bloody move. Now she say, gon' do what or who? Let's find out and see. Cardi B, you know where I'm at, you know where I be. Just a party, I'm there, I can play. I be in and out the bank so much, I know they tired of me. Honest, honest.
You are watching Diva, divine light, light, light.
You can fuck with me if the pieces red bottoms, these bloody shoes. Hit the scoop, I can get them both. I don't want to choose, and I'm quick. Cut every nigga off, so don't get comfortable. Look, I don't dance now, I make money move. Now I gotta dance, I make money move. If I see you now, that means I don't fuck with you. I'm a boss, you a worker, bitch. I make bloody move. Now she say, gon' do what or who? Let's find out and see. Cardi B, you know where I'm at, you know where I be. Just a party, I'm there, I can play. I be in and out the game so much, I know they tired of me. Honest, honest.
You are watching Diva, divine light, light, light.
You can fuck with me if the pieces red bottoms, these bloody shoes. Hit the scoop, I can get them both. I don't want to choose, and I'm quick. Cut every nigga off, so don't get comfortable. Look, I don't dance now, I make money move. Now I gotta dance, I make money move. If I see you now, that means I don't fuck with you. I'm a boss, you a worker, bitch. I make bloody move. Now she say, gon' do what or who? Let's find out and see. Cardi B, you know where I'm at, you know where I be. Just a party, I'm there, I can play. I be in and out the game so much, I know they tired of me. Honest, honest.
You are watching Diva, divine light, light, light.
You can fuck with me if the pieces red bottoms, these bloody shoes. Hit the scoop, I can get them both. I don't want to choose, and I'm quick. Cut every nigga off, so don't get comfortable. Look, I don't dance now, I make money move. Now I gotta dance, I make money move. If I see you now, that means I don't fuck with you. I'm a boss, you a worker, bitch. I make bloody move. Now she say, gon' do what or who? Let's find out and see. Cardi B, you know where I'm at, you know where I be. Just a party, I'm there, I can play. I be in and out the game so much, I know they tired of me. Honest, honest.
You are watching Diva, divine light, light, light.
Sorry, guys, I'm back. Had to use the restroom as well. Sorry, y'all. All right, so let me finish this and then I could get out of here. All right. So now the government's evidence of intent as to the Mann Act violations related to Jane and Faith were insufficient. Defendant relies largely on the arguments contained in his opening brief concerning the sufficiency of the evidence as to Mann Act violations related to Jane and Faith. However, it bears repeating that the government cannot and did not prove that defendant's motivating purpose in transporting Jane and Faith to California and New York was to expose them to herpes in violation of state public health laws. The district court got it wrong when it held that the intent element is satisfied by a general intent to engage in legal sex that could be criminally prosecuted for reasons unrelated to the travel. Recognizing the district court's flawed analysis, the government attempts to fold the prohibited sexual activity into the real purpose of the travel, arguing that defendant's motivating purpose for the travel was to engage in unprotected sex in his usual manner without first informing her that he had contracted herpes and obtaining her consent to sexual intercourse in those circumstances. The government's word games do not save their argument. Girl, your word games do not save your argument. You're going to lose this one. Defendant's intent in arranging travel for Jane and Faith was not to give them herpes or expose them to an STD. It was to engage them in sexual activity and not necessarily sexual intercourse, the only way to expose them to an STD. The exposure to herpes was merely incidental to the travel. To hold otherwise would mean that even if defendant never went to Faith's hotel room after arranging for her travel there and never had sex with her, he would still be guilty of violating the Mann Act for intending to expose her to a sexually transmitted disease. This absurd result undermines the government's contention. The government's attempt to avoid its burden of proof by conflating the incidental consequence, exposure to herpes, into the true purpose of the travel. Legal sexual activities must be rejected. Defendant was denied a fair and impartial jury where several of the seated jurors admitted that they prejudged the defendant's guilt, and trial counsel provided ineffective assistance of counsel when he failed to move to disqualify patently unqualified jurors. Contrary to the government's argument, defendant is not generally complaining that his trial counsel could have done more during the voir dire. Rather, defendant contends that his counsel's performance was objectively unreasonable when he did not object to the seating of multiple jurors who, 1, had seen surviving R. Kelly, 2, were aware of defendant's reputation that he loves little girls, and 3, were familiar with his prior legal troubles, including his criminal prosecution for creating sexually explicit videos with a minor. Had there been even one juror who had seen surviving R. Kelly seated on defendant's jury, his jury could not be deemed impartial. The government minimizes the extraordinary prejudice that defendant suffered as a result of his counsel's deficient performance. The government argues that defendant cannot demonstrate prejudice because he cannot show that any juror had actual bias. This record demonstrates that before stepping into the courtroom, 2 jurors heard over 360 minutes of victims' testimonies, including graphic accounts of urinating on 14-year-olds. If this type of information does not lead to the inference that a person will not and cannot act with impartiality, it is difficult to imagine what would. A whopping 6 jurors were familiar with allegations that defendant had previously sexually abused minors and had faced legal consequences for such conduct. The government attempts to trivialize the prejudice to defendant, but it is simply beyond debate that defendant's jurors suffered from actual biases. Frankly, even if defendant cannot show actual bias should be presumed here. The United States Supreme Court has observed a fair trial in a fair tribunal. I can't say the word, is a basic requirement of due process. Fairness, of course, requires an absence of actual bias in the trial of cases, but our system of laws has always endeavored to prevent even the probability of unfairness to perform its high function in the best way. Justice must satisfy the appearance of justice. And then it cites another case from 1965. As Chief Justice Taft said in Turney versus Ohio, a case in 1927, the requirement of due process law in judicial procedures is not satisfied by the argument that men of the highest honor and the greatest self sacrifice could carry it on without danger of injustice. Every procedure which would offer a possible temptation to the average man. To forget the burden of proof required to convict the defendant, or which might lead him not to hold the balance nice, clear, and true between the state and the accused, denies the latter due process of law. Wow. Indeed, the United States Supreme Court has struck down convictions irrespective of a showing of actual bias, where prejudice is inherent in those convictions. This is a case where prejudice is inherent in defendant's convictions because fully half of his jury was exposed to highly prejudicial and inadmissible evidence that invariably interfered with defendant's cherished constitutional safeguards. In the old but highly instructive case of Marshall versus United States, 1959, the United States Supreme Court reversed the defendant's drug conviction after concluding that exposure of some of the jurors to newspaper articles was so prejudicial to justify a new trial. During the defendant's trial, 2 newspaper articles got before a substantial number of jurors. The news accounts contained information that the defendant had two previous felony convictions and detailed the circumstances of prior arrests and convictions. Upon learning that the news accounts had reached the jurors, the trial judge questioned the jurors about whether they had seen the articles. 7 of the jurors had some exposure to the articles, but all asserted that the trial judge, that they would not be influenced by the news articles and could decide the case on the evidence in the record. The trial judge denied the defendant's motion for a mistrial, finding that there was no prejudice to the defendant. The United States Supreme Court reversed, finding, we have here the exposure of jurors to information of a character which the trial judge ruled was so prejudicial it could not be directly offered as evidence. The prejudice to the defendant is almost certain to be as great when that evidence reaches the jury through news accounts as when it is part of the prosecution's evidence. It may indeed be greater, for it is then not tempered by protective procedures. Consistent with the teachings of Marshall, defendant is entitled to a new trial. 4 jurors were exposed to information of a character that was so prejudicial that it could not be offered into evidence. Indeed, had trial counsel simply moved to disqualify these jurors, it seems likely that those motions for cause would have been allowed. Prejudice to the defendant must be presumed given the inflammatory nature of the information that no average human could put aside. Defendant's convictions must be vacated and the new trial ordered. For the remainder of the defendant's arguments, he relies on his opening brief. Respectfully submitted, Bonjean. Well, that is the end of that. And, guys, there was also the government had put in a declaration in support of an order of garnishment and proposed order of garnishment of your honor's review and signature. The proposed order provides for the garnishment of music publishing royalties currently held by Universal Music Publishing, Inc. Universal, to fully satisfy the defendant's restitution obligation. Further, because the government can likely satisfy the entirety of the restitution debt via the monies held by Universal, the government respectfully withdraws its writ of continuing garnishment filed on June 1st, 2023 against Sony Music, entry number 361, without prejudice. The government thanks the court for its consideration of this matter. So the government withdraws its writ of continuing garnishment against Sony Music. And that's because the government can likely satisfy the entirety of the restitution debt via the monies held by Universal. So they're dropping the writ against Sony Music because Sony Music doesn't have his money. It's Universal Music. It's Universal Music Publishing, Inc. that owns R. Kelly's music now. So they are holding on to his masters. So this is how he's getting paid his royalties, through Universal Music Publishing, not through Sony. So, okay. So, Daniel Saavedra hereby declares as follows. I am an assistant United States Attorney of Counsel to Breon Peace, United States Attorney for Eastern District of New York, Attorney for the United States of America, and am responsible for the collection of the judgment against defendant Robert Sylvester Kelly, the defendant in the above referenced case. On June 1st, 2023, the government initiated this garnishment proceeding by the filing of an application for a writ of continuing garnishment. That application was filed in order to enforce the judgment of restitution imposed by the court on July 17th of 2022 in the amount of $520,549.90 plus interest against the defendant and in favor of the United States of America. As of August 15th, 2023, the defendant has made payments totaling $27,828.24 toward the restitution judgment. As of August 15th, 2023, the defendant is currently indebted to the United States of America in the amount of $506,950.26. Interest is continuing to accrue on the debt. Now, on June 1st, 2023, the government served Universal Music Publishing, the garnishee of Universal Music Publishing, via counsel with government's application for writ of continuing garnishment, the writ of continuing garnishment instructions to the garnishee and related documents. The defendant was properly served with the writ of continuing garnishment and notified of his right to a hearing or to file a claim for exemption, but has not requested a hearing, claimed an exemption, or otherwise contested the garnishment proceedings, and the statutory time to do so has expired. So Universal Music Publishing served an answer to the writ of continuing garnishment, dated June 21st of 2023, which was subsequently entered on the docket sheet as document number 364 on July 5th of 2023, and which stated that it had following non-earnings property in its custody, control, or possession. Music publishing royalties with a value of $567,444.19. So Universal Music Publishing anticipates owing music publishing royalties to Defendant in the future. The amount of future royalties is unknown because it depends on the extent to which Defendant's musical compositions are purchased, downloaded, synchronized, or otherwise exploited during future royalty accounting periods. Royalties are accounted on a semi-annual basis. Royalties for the accounting period running from January 1st, 2023 to June 30th of 2023 are due to be paid on or before September 30th of 2023. Royalties for the accounting period running from July 1st, 2023 to December 31st of 2023 are due to be paid on or before March 31st of 2024. So Universal Music Publishing further stated it does not have custody, control, or possession of any other property in which defendant maintains an interest. Pursuant to the writ of continuing garnishment and as provided in 28 U.S.C. 3205, Universal Music Publishing, as the garnishee, is required to withhold and retain, pending further order of the court, any property in which the defendant has a substantial non-exempt interest. Pursuant to the 28 U.S.C. 3205 C7, the court shall issue an order of garnishment directing the garnishee as to the disposition of the defendant's non-exempt interest in the property. After the garnishee files an answer, and if no hearing is requested within the required time period, based on the foregoing, the United States seeks an order directing Universal Music Publishing to issue a check within 10 days of receiving a certified copy of the order of garnishment, payable to the clerk of the Court of the Eastern District of New York for the full amount of restitution debt owed by the defendant. As of the date Universal Music Publishing receives the certified copy of the order of garnishment, and that said check be mailed or delivered to the clerk of the Court for the Eastern District of New York, 225 Cadman Plaza, Brooklyn, New York, 11201, and reference United States versus S. Kelly, CR 19-02886, AMD on its face. A copy of the instant declaration and the accompanying proposed order of garnishment will be e-filed with the court and served on Universal Music Publishing at 2100 Colorado Avenue, Santa Monica, California 90404, and through counsel. Wherefore, the United States of America respectfully requests that the court issue an order requiring that within 10 days of receipt of service of a certified copy of the order of garnishment, Universal Music Publishing, Inc. shall issue a check payable to clerk of the Court for the Eastern District of New York in the full amount of the restitution debt owed by the defendant as of the date Universal Music Publishing, Inc. receives the certified copy of the order of garnishment, and that said check be mailed or delivered to the clerk of the Court for the Eastern District of New York, 225 Cadman Plaza, Brooklyn, New York, 11201, and reference United States Robert Sylvester Kelly, 190286 on its face. I declare under penalty of perjury that the foregoing is true and accurate to the best of my knowledge, information, and belief, that the amount claimed is justly due and owing to the United States, and that the disbursements sought to be taxed have been made in this action or will necessarily be made or incurred in this action. So they got 10 days to respond. Okay. So that is that. Mm, mm, mm. Wow. Hey, Mertice, what's up? I believe this appeal will be denied, and the more errors of judgment she makes could force them to add time under grounds of being too lenient. More so with Chicago, though that really was too lenient. I agree with that, SK. Nor did all witnesses survivors get to take the stand. Some Jane Does were left out. Let's say RSK got a new trial, which is unlikely. Would they have to use the same evidence, or could they add to it the stuff they didn't use? Yes, baby, they can add new evidence. It's a new trial. They sure can. They sure can. Hey, Matisse, what's up, mama? She is making sound like they didn't have 100 devices, that exposure to them will be detrimental to him. It just surprises me that only one STD has ever been brought to court when he didn't even wash between women because he didn't like showers or baths. You know what? That's a big reason why he got sick too. Being dirty and sticking one girl and then sticking the other and then sticking the other and sticking the other and then not showering. Leaving all that crust and shit on your cock. Like, what are we doing? And the fact it smelled bad proves he was probably sharing more than herpes. I don't believe that's all he passed on to those girls, as they were way too much unprotected sex with multiple. Well, he did have herpes and I'm sorry, he did have gonorrhea and chlamydia, I believe. I'm still here. You're in the bushes. Okay, Ty. Liar, pants on fire. He sure did. He's a sick fuck. He intended to expose them unprotected while. Yeah, I read that. Okay. Yeah, guys, don't forget to hit the like button, please. Thank you. Bye, baby. Love you, mama. Thank you for stopping by, guys. He couldn't have done it all alone. No enterprise. The man isn't even capable of arranging all the shit alone and getting away with it. He's dyslexic. Right. He's dyslexic. Right. Bunjean should just say, is tried, boss. What? Oh my God, they did. They helped him. Without them, he wouldn't have got away with what he did for years. Exactly. 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 So my appeal would be to get the others locked up too. Scrap the plea deals, lock the rest up. Really? For real, the only thing wrong with this whole case, in my opinion, is too many people walked away. I agree with that. What should be behind bars too? Yeah, I agree with that. I totally agree with that. I don't think he's the only one should have been held accountable at all. I don't think he should have been the only one either. I really don't. I really don't. It's upsetting the way these laws work, and some of it works for you, some of it doesn't. That's just the fucked up system we got. They just wasting taxpayers' money with all this damn bullshit. What in the entire hell? It's crazy how he got off, and just like that, Narky is continued his abuse. He thought he was untouchable, right? She thought it was simple and about racism and money. I mean, part of the money thing is true, but he still did it all, and the charges are correct. I agree with that too. You know, people stole from him. I get it. Hey, True Strong Warrior, what's up, mama? I don't think she studied the case. I read that. She really doesn't know the case well, or it's such a lot. She doesn't do her research. I think she definitely be more than she can chew. She bit off more than she can chew. Yeah, I agree. She did, and she's got a lot of other cases. You know. And ladies, thank you so much for the super stickers. Thank you so much, ladies. So I am going to end this live, guys. Thank you all for coming. Like I said, I know we're on repeat. You know, we really are at this point. But I got some newbies that come by and watch too, you know. So for all you newbies, you know, I'm kind of going through it and rewinding back in time. So guys, donations are appreciated. You can Cash App Diva Divine Light, or you can PayPal me. My Cash App is $ Diva Divine Light. I need help paying my Pacer bill. I'm still like $70 short, guys. So if you can, hit the Cash App, please, to help a sister out with paying this Pacer bill, or I won't be able to get back in. I got till the 21st, so if you guys can help a sister out, that would be wonderful. And don't forget, guys, hit that like button on your way out, please. Thank you very much. And we will be getting into Trump's indictment and all of that as well. I'll come back tomorrow. All right. And for those who are on the replay, please make sure you leave your comments. Make sure they're respectful. All right. And your girl Diva Divine Light is out. Thanks for coming, guys. Don't forget to hit the like button. Peace.
You are watching Diva Divine Light.
You can fuck with me if these is red bottoms, these is bloody shoes. Hit the scoop, I can get them both. I don't want to choose, and I'm quick. Cut a little nigga off, so don't get comfortable. Look, I don't dance now, I make money move. Now I gotta dance, I make money move. If I see you now, that means I don't fuck with you. I'm a boss, you a worker, bitch. I make bloody move. Now she say, gon' do what or who? Let's find out and see. Cardi B, you know where I'm at, you know where I be. Just a party, I'm there, I can play. I be in and out the game so much, I know they tired of me. Honest.